Bismillahirrahmanirrahim. Assalamu alaikum. Today we will discuss about criminal justice system in Pakistan. So let's start. Starting from the definition of criminal justice, the study of crimes is styled as criminology, and the study of the agencies that control or respond to crime is called criminal justice. So, criminal justice system is a series of government agencies and institutions. Further, we can say that criminal justice is the system in which crime and criminals are detected, detained, tried, and punished. So, the term criminal justice system refers to the components of the government charged with enforcing law, adjudicating criminals, and correcting criminal conduct. In short, we can say that our criminal justice system refers to the components of the government that enforce law, educate criminals, and correcting criminal conduct. So, moving next. Uh, Now we will discuss about components of criminal justice system. Criminal justice system of Pakistan composed of three main components that are police, that can play role in investigation. Second component is courts that play important role in conviction. And number third is prisons where sentence is served. So we can say that criminal justice system of Pakistan composed of three components, that is police, courts, and prisons. Now we will talk about objectives of criminal justice system of Pakistan. So we can say that when we talk about a criminal justice system of Pakistan, there should be some kinds of objectives. So we can say that to prevent occurrence of crime, to punish the criminals, to have rehabilitate the criminals, to compensate the victims as far as possible, to maintain law and order in the society, to deter the offenders from committing any criminal act in the future. So we can say that in order to create a criminal justice system of Pakistan, these six motives, these six objectives were in mind. So we can say that prevention for the occurrence of crime, or we can say that if crime occurs, then punishment of the criminal, and if punishment occurs, then how we can. So we can say that how to rehabilitate the criminal is the third objective of criminal justice system of Pakistan. Now moving towards fourth objective, to compensate the victims as far as possible. In this, we can say that what are the main requirements to compensate the victims as soon as possible. Number fifth is to maintain law and order in the society. How we can maintain law and order in the society? Uh, Criminal justice system has a main objective, because we just discussed that criminal justice system of Pakistan refers to the agencies that enforce law, educate criminals, etc. So, in order to maintain law and order in the society, in order to maintain peace in the society, criminal justice system of Pakistan played an important role. So, the last one objective of criminal justice system is to deter the offenders from committing any criminal act in the future. In short, we can say that in order to create the criminal justice system of Pakistan, what was the main objective behind that? Uh, we should discuss about prevention, punishment, rehabilitation, compensation, maintenance of law and order in the society, and the last one, deterrence of the offender from committing any criminal act in the future. Now, what are the goals of criminal justice system? The rehabilitation, correction of offenders, preventing other crimes, moral support for victims. So these are the three main goals of criminal justice system: the rehabilitation, prevention, and moral support for victims. Now we will discuss about the primary institutions of the criminal justice system of Pakistan. As we talk about law enforcement agencies, prosecution, courts, and corrections, and these four played an important role in making a community. So we can say that what are the basic primary institutions of the criminal justice system? Firstly, we talk about police. Next is prosecution and defense lawyers. Third one, the courts. Fourth one, prison correction institutions. Interesting fact is that each component has its own function, having their own organization, having their own budget, working, and legal framework. So, a brief introduction to each component is given. First of all, we will talk about police. The police may the first component of criminal justice system of Pakistan. Let's start. In criminology, police as an organization, whereas policing is the function of preventing and detecting crime. We are discussing topic of criminology. What is criminology? Criminology is the scientific study of crime, extent and nature of crime, causes of crime, prevention of crime, reaction of crime by the criminal justice system. In criminology, police is basically an organization where policing is the function. What type of function it performed? It performed preventing and it performed prevention and detection of crime. So, the powers of policing are provided by the Code of Criminal Procedure, and all police organizations derive their police powers from it. The first contact a defendant has with the criminal justice system is usually with the police or law enforcement who investigates the suspected wrongdoing and makes an arrest. But if the suspect is dangerous to the whole nation, a national level law enforcement agency is called in. Here we will talk about some kinds of policing agencies. Like if we talk about at national level, we talk about if at national level, we talk about different law enforcement agency. But if we talk about international level, we will discuss about Interpol and IPA. Okay, next one is when warranted. Law enforcement agencies or police officers are empowered to use force and other forms of legal coercion and means to affect public and social order. The term is mostly commonly associated with the police departments of a state that are authorized to exercise the police power of that state within a defined legal or territorial area of responsibility. When a has been issued, then we can say that different law enforcement agencies got the power to use force and other forms of legal coercion and means to affect public and social order. Further, we can say that it's a term that is associated with the police departments of a particular state that has authority that are authorized to exercise the police power of that particular state within a defined legal or within a defined legal territorial area. Further, we can say that the legal framework of policing primarily supports detection model of policing by providing legal basis of investigation and subsequent processes. It provides very limited powers of preventing crime to the police organizations. Now, what is the role of police? Law enforcement is the main role of police. As we talk about the process, or we talk about the criminal justice system of Pakistan that refers to the law enforcement agencies. Uh, what is the role of police in criminal justice system of Pakistan? Let's start. Identifying criminal suspects, investigating crimes, apprehending offenders, and participating in their trials, deterring crime through patrol. These are the main role of police. What further we will discuss about the main thing that is police have numerous other responsibilities that includes patrols, traffic control, first aid, general safety issues, community relations, and many other police are trained locally and are responsible for maintaining training throughout their careers. Police is a body of officers representing the civil authority of government. Police typically are responsible for maintaining public order and safety, enforcing the law, and preventing, detecting, and investigating criminal activities. So, here I hope so. You understand. What is the second main order? What is the second main role of police in the criminal justice system of Pakistan? That is the order maintenance. In order to create peace, in order to create harmony, what the major role police played. So we will discuss about resolving conflicts and keeping the peace, maintaining the sense of community security, promoting civil order, maintaining administrating police services, public education, aiding aiding individuals in danger or in need of assistance. So, in short, we can say that the police in general are responsible for the protection and service of the communities that they serve. They are given a large amount of responsibility. They're allowed to use escalating force. They are usually given a tremendous amount of independence in the crime suppression, investigation, and law enforcement duties. A very small percentage of police time is spent on fighting crime. Further, we can say that what are the main goals of policing? So these are to prevent crime and protect life, uphold and enforce the law, combat public fear of crime. We can say that police had played or is playing a major role in creating deterrence over the society. Okay. Next one is promote community safety, control traffic, encourage respect for the law, and protect civil rights and liberties. So now we will discuss about the second or main institution of criminal justice system of Pakistan, that is prosecution. So let's start. The function of the prosecution is to evaluate the evidence collected by police and filter the quality and quantity of cases to be sent up for trial. Historically, it was part of police organizations. Now, what is who is prosecutor? The prosecutor or district attorney is a lawyer who brings charges against a persons, or corporate entity. Entity means a body. It is the prosecutor's duty to explain to the court what crime was committed and to detail what evidence has been found which incriminates the accused. Further, we can say that the prosecutor should not be confused with the plaintiff or plaintiff counsel. So here the word plaintiff means the, or we can say complainant, and the person who brings actions in the court of law. So, moving forward, although both serve the function of bringing a complaint before the court, the prosecutor is a servant of the court who makes accusations on behalf of the state in criminal proceedings, while the plaintiff is the complaining party in civil proceedings. The defense attorney counsels the accused on the legal process, likely outcomes for the accused, and suggests strategies. It is the defense attorney's duty to represent the interest of the client, raise procedural and evidentiary issues, and hold the prosecution to its burden of proving guilt beyond a reasonable doubt. Defense counsel may challenge evidence presented by the prosecution and argue on behalf of their client. So, in short, we can say that the main function of prosecution is to evaluate the evidence collected by police and filter that evidence, filter the quality and quantity of case. So, this proceeding will move towards a trial. Historically, we can say that historically, prosecution was the part of police organizations, and the person who is in the process of prosecution or who played an important role in the prosecution is the prosecutor or district attorney. And who is the prosecutor and district attorney? He is a lawyer who brings charges against a persons or corporate entity. What are the main roles what are the main functions that a prosecutor perform? He counsels the accused on the legal process, likely outcomes for the accused, and suggests him different strategies. And further, he represents the interest of the client, raise procedural and evidentiary issues. So, in order to hold the prosecution to its burden of proving guilt beyond a reasonable doubt. Now, what are the main roles of prosecutor? In short, we can say that it to investigate the law violation, cooperating with police, determining the charge, representing the government at pre-trial and hearing, Here, pre-trial and we will discuss about preliminary investigation in Section 3. Plea bargaining recommends sentence, representing the governments and appeals, conducting special investigation. So these are the role of prosecutor. Uh, these are the main role of prosecutor, in short, in the criminal justice system of Pakistan. Now we will discuss about the role of defense attorney uh, to investigate the incident, interviewing the client, police officers, and other witnesses, discussing matter with the prosecutor, representing the defendant at various procedures, entering into plea negotiations, and further preparing the case for trial, including developing strategies. Filling and arguing legal notions, ideas with the court, representing the defendant at trial, providing assistance at sentencing, determining the appropriate basis of appeal. These are the basic roles of defense attorney. Now, we will discuss about the third main institution of criminal justice system of Pakistan, that is court. Basically, the court serves as the venue where disputes settled and justice is administered. With regard to criminal justice, there are a number of critical people and in any court setting. These include the judge, prosecutor, and the defense attorney. The judge or magistrate is a person elected or appointed who is knowledgeable in the law and whose function is to objectively administer the legal proceedings and offer a final decision to dispose of a case. The magistrates have the charge of different police stations and their working is as important as of police stations. Now, in short, we can say that basically, courts are the venue where disputes are settled and justice is administered, where justice is the main requirement of that particular venue. With regard to criminal justice, when we discuss about court with criminal justice, then we can say that there are a number of critical people in any court setting. Or these court setting includes the judge, prosecutor, and defense attorney. These are the main components of any court. These are the main component of in any court setting, where the judge or magistrate, a judge or a magistrate are the same person. These are the person. It is a person who elect or appoint, who is knowledgeable in the law and whose function is to objectively administrate the legal proceedings and offer a final decision to dispose of a case. Further, we can say that the magistrates have the charge of different police stations. It can uphold on the different police stations. It has the charge on over different police stations, and the working is as important as of police stations. Further, all the accused of arrest have to be produced before court within 24 hours in accordance with the Constitution, Article 10. Okay, according to Article 10 of the Constitution, all the accused, all the accused persons, who is accused, the person who is arrested as the suspected one, and the person who is under trial and the crime has not been legally proved on him. So we can say that under the Constitution, Article 10, all the accused of arrest have to be produced before court within 24 hours in accordance. So the courts follow adversarial system of adjudication, and the criminal cases are to be proved beyond any shadow of doubt, and the accused is treated as innocent unless proven guilty. Now, what is the role of judge? What is the role of judge in criminal justice system of Pakistan? So, the major participant in the criminal justice system is the judge. Is the main component of the criminal justice system of Pakistan. He is the senior most officer of the court. He is the most senior one. So, in order to create a good conduct in the court setting or in the court during trial, judge played an important role. So we can say that during trial, the judge rules on the appropriateness of conduct, settles the questions of evidence and procedure, and guide the questions of the witnesses. When a jury trial occurs, the judge must instruct a jury members on which evidence can be examined and on which should be ignored. The judge also firmly charges the jury by instructing its members on what points of the law and evidence they must consider before reaching the decision of guilty or innocent. Finally, if the defendant is found guilty, the judge decides on the sentence. Now we will talk about the fourth main institution, that is prison and correction. So, offenders are then turned over to the correctional authorities from the court system after the accused has been found guilty. Corrections refers to the supervision of persons arrested for, convicted of, or sentenced for criminal offenses. Correctional populations fall into two general categories. Here we will discuss about the two main corrections uh, general categories of prison corrections. These are institutional corrections, and the other one is community corrections. What is community correction? It is the supervision of criminal offenders in the resident population as opposed to confining offenders in secure correctional facilities. The two main types of two main types of community correction supervision are probation and parole. Here, the words probation and parole will discuss in next slide. Okay, what are the corrections? Correction is a branch of criminal justice system concerned with the custody, supervision, and rehabilitation of criminal offenders. What is correctional administration? It is the study and practice of system management of jails or prisons and other institutions concerned with the custody, treatment, and rehabilitation of criminal offenders. In short, we can say that prison and corrections had played an important role over the corrections. These are the authorities that supervise the person who is arrested for, convicted of, or sentenced for criminal offenses. Further, we can say that correctional populations fall into two general categories, that are institutional correctional corrections and the community corrections. So we will discuss about talk about probation. What is probation? It is the first time offenders may be released by the court on surety. Probation may be applied as an alternate to imprisonment. So we can say that the concept of probation is that first time offenders may be released by the court on surety. Probation may be applied as an alternate to imprisonment. Probation can have a number of different supervision statuses, including the active supervision and the inactive status. Inactive supervision, we can discuss about the means they are required to regularly report to a probation authority in person, by mail, or by telephone. And then other one, the inactive status, we will discuss about that they are excluded from regularly reporting, and that could be due to a number of reasons. In many instances, while on probation, offenders are required to fulfill certain conditions of the supervision. Here, the word supervision means that is for the payment of fines, for fees, or cost, participation in treatment programs, and further adhere to specific rules of conduct within the community. Failure to comply with any conditions can result in incarceration. So, we can say that probation is the basic concept how the first time offenders may be released by the court on surety. It is the process, it is the concept which can be applied as an alternate to imprisonment. We can further say that probation can have different number of supervision statuses, including the two main components or two main different supervision statuses that are active supervision and inactive status. In active supervision, we can say that it requires regularly report to a probation authority in person, by mail, or by telephone. Inactive status requires that, or it can be defined as they are excluded from regularly reporting and can be due to a number of reasons. Within many instances, we can say that when a person is on their probation, offenders are required to fulfill certain conditions of their supervision. For example, they have to pay the fines, they have to pay the fee, they have to or pay the fee of court they have to pay the court cost, participation in the treatment programs, and further they can adhere to the specific rules of conduct while living in the community. Now we'll talk about parole. What is parole? It refers to the criminal offenders who are conditionally released from prison to serve the remaining portion of their sentence in the community. So, paroles can have a number of different supervision statuses, including active supervision and inactive supervision. These are the same supervision statuses, just like probation. So, but there is a hell of difference between these two words. Okay, active supervision, which means they are required to regularly report to a parole authority in person, by mail, or by telephone, and in inactive statuses, which means they are excluded from the regular reporting. Paroles are also typically required to fulfill certain conditions and adhere to specific rules of conduct while in the community. Failure to comply with any of the conditions can result in a result to incarceration. Release on parole is always conditional, and paroles must follow the conditions of the release. And further, we can say that a parole refers to the criminal offenders who are conditionally released from the prison to serve the remaining portion of their sentence in the community. Further, we talk about the number of different supervision statuses, including the active supervision and the inactive statuses. Active supervision, which means they are required to regularly report to a parole authority in person. Our inactive status means that they exclude from the regularly reporting. The major steps in processing a criminal case are as follows. Now, these are the major steps which can be important, which can play an important role in a criminal case, in the processing of a criminal case. First is the investigation of a crime by the police. As we talk about the police, the policing is police is an organization where policing is the main function, and in order to create deterrence over the society, police play an important role. The purpose of a criminal investigation is to gather evidence to identify a suspect and support an arrest. An investigation may require a search and exploratory inspection of a person or property. Probable cause is the standard of proof required for a search. Probable cause means that there are facts or appearance facts indicating that evidence of criminality can be found in a specific place. So, we can say that investigation of a crime by the police of a criminal justice system, the purpose is to gather the evidence whether to identify a suspect and whether to support an arrest. An investigation may require a search and exploratory inspection of a person or a particular property. What are the probable cause? Probable causes are the standard of proof required for that particular search in order to find out the truth. Probable cause means that there are the facts or apparent facts indicating that evidence of criminality can be found in a specific place. Now we will talk about arrest of suspect by the police. This is we can say that an arrest involves taking a person into custody for the purpose of holding the suspect until court. Probable cause is the legal requirement for an arrest. It means that there is a reasonable link between a specific person and a particular crime. Prosecution of a criminal defendant by a district attorney when deciding whether to charge a person with crime. Prosecutors weigh many factors, including the seriousness of the offenses and the strength of the evidence. Arraignment by a judge. Before the trial, the defendant appears in court and enters a plea. Before going towards the court proceeding, before the trial, the defendant has to appear in the court and enters a plea. The most common pleas are guilty and not guilty. We can say that a plea can be a guilty or not guilty. Arraignment is the first hearing after arrest. So here we will discuss a few points that are learning the reason of arrest, informed rights to defendant, assignment of an attorney. Arraignment is not a trial. No one is found guilty or not guilty. Or the evidences, no evidence or witnesses are presented. So we can say that a Remand judge, it's a before the trial, the defendant has to appear in the court and enters a plea procedure. The most common pleas are guilty and maybe not guilty. A remand is basically the first hearing after arrest. After arrest is the first hearing, in which learning the reason of arrest, in order to learn the reason of arrest, in order to inform the rights to defendant, in order to the assignment of an attorney. Arraignment is not a trial. We can say that arraignment is not a trial. It's a different thing from trial. And no one is found guilty or not guilty. No evidences or witnesses are presented. Now, what is pre-trial detention under bail? Detention refers to a period of temporary custody prior to trial. Bail is an amount of money paid by a defendant to ensure he or she will show up for a trial. So we can say that pre-trial detention and or bail. Detention refers to a period of temporary custody prior to the trial. Bail is an amount of money paid by the defendant to ensure he or she will appear for trial. Next one is plea bargaining. Plea bargaining between the defense attorney and the prosecutor. Usually in plea bargaining, the defendant agrees to plead guilty in exchange for a charge reduction or sentence reduction. In law practices of negotiating an argument, prosecution and the defense, whereby the defendant pleads guilty to a lesser offense, or in the case of multiple offenses, to one or more of the offenses charged in exchange for more lenient sentencing, recommendations, a specific sentence, or a dismissal of other charges. Trial adjudication of guilt by a jury or a jury. With the prosecutor and the defense attorney participating, a trial is basically a trial is held before a judge or jury. The standard of evidence for a criminal conviction is guilt beyond a reasonable doubt. Less than 100% certainty, but more than high probability. If there is doubt based on reason, the accused is entitled to the acquitted. So, last one is the sentencing by a judge. If the accused is found guilty, if the accused is found guilty, a judge meets out a sentence. Possible sentences include a fine, probation, a period of incarceration in a correctional institution, such as we'll talk about jail or prison, or some combination of supervision in the community. So here, we discuss four main things: the pre-trial detention or bail, plea bargaining, trial or adjudicating the guilt by a judge or jury, and the last one, sentencing by a judge. Uh, so, in short, we can say that pre-trial is the temporary custody prior to trial. Plea bargaining is between the defense attorney and the prosecutor, and we can say the defendant agrees to plead guilty in exchange for a charge reduction. In order to the law practice of negotiating an agreement between prosecution and the defense, whereby the defendant pleads guilty to a lesser offense or in to one or more of the offenses charged in exchange for more lenient sentencing. For the recommendations, a specific sentence or dismissal of the other charges. Next one, we talk about trial adjudication of guilt by jury, judge or jury. So we can say that within with the prosecutor and defense attorney participating, a trial is held before a judge or jury. The standard of evidence is the main requirement for the trial process, as the guilt is beyond a reasonable doubt, less than 100% certainty, but having the more high probability. Last one we'll discuss about sentencing by a judge. If the accused is found guilty, a judge meets out a sentence. Possible sentences include fine, probation, a period of incarceration in a correctional institutions, for example, jail or prison, or some combination of supervision in the community. Next is appeals. Appeals that are filed by attorneys and appellate courts and then ruled on by appellate judges. If an appellate court reverses a case, the case returns to trial court for retrial. With the reversal, the original trial becomes moot. That is, it is as though it never happened. Following a reversal, the prosecutor decides whether to refile or drop the charges. Even if a prosecutor drops the charges, the defendant can still be prosecuted later as long as the statute of limitations for the crime the defendant is accused of committing has not run out. Such a statute imposes time limits on the government to try a case, but we can say that appeals they are the appeals that are filled by the attorneys and appellate courts. Uh, Appellate courts have appeals, and then we can say that it ruled on by the appellate judges. We As we talk about court, which is the second main institution, which is the second main component of the criminal justice system of Pakistan, and here we had talk about and there we had talked about the panel settings, the judge or magistrate that ruled over the whole court. So here the appellate judges are the main heads of the appellate courts, and we can say that if an appellate court reverses a case, the case returns to court for retrial, and within a reversal, the original trial becomes moot. That is, it as though it never had happened. Okay, now we will talk about punishment and rehabilitation administered by local, state, or legal and federal correctional authorities. Most inmates do not serve the complete term and are released before the expiration of their maximum sentences. Release may be obtained by serving the maximum sentence mandated by a court or through an early release mechanism such as parole or pardon. So, in order for the administration by local, state, or for federal correctional authorities, punishment and rehabilitation are the two main things. Whether or not to serve the complete term and release before the expiration of their maximum sentences, release can be obtained by serving the maximum sentence, and which are the mandatory requirements given by a particular court through an early release mechanism, such as had talked about parole or pardon. Hope so everything will be clear to you all. See you in next class. Allah Hafiz.